There it is, and we will go ahead and do our quick poll. So if everyone could just answer these two questions, then we'll go ahead and introduce our topic and speaker. I always love to see them come in. You guys answer so quickly. I love it. Give it just about 30 more seconds. All right, that is our poll. Thank you all for participating. Going to X that out and introduce you guys to Gayle. Gayle Owens is a practicing attorney since 2000. She has a broad base of experience in business law, estate planning, and probate. She is an advocate for estate planning, especially for families with special needs or at-risk family members, and believes in educating clients in the complex legal issues involved. Tonight, Ms. Owens will share information on the purpose, objectives, and options in estate planning and teach you guys how a special needs trust works and why it may be needed. Of course, there will be plenty of time for questions and discussion towards the end. And with that, I will pass it over to Gayle.
Thank you, Erin. Again, I'm Gayle Owens, and I'm just going to go ahead and get right into things. I'm going to share, some slides, kind of follow along with what I'll be covering. But essentially, we're looking at estate planning for leaving assets to your loved ones, whether that be someone with special needs or someone maybe in danger of not being able to handle the assets, and what are some of the considerations in that. Typically, I'm looking at those folks with a moderate estate. If you're someone who's got millions, you already are working with an attorney, and they're going to set some pretty complex things up for you. So I'm really talking about people who have more modest estates, who maybe can't afford professional trustees for a trust, and what are the considerations that you have to take in that kind of estate plan. So and then I'm going to leave time for questions as we go forward. Okay, all right, first of all, my legal disclaimer, got to do it. This is for educational purposes only. I'm not giving legal advice here. So you keep in mind that these are complex issues, and you don't want to rely on just this seminar in doing anything that would have any kind of permanent effect. You want to be sure you speak on your specific situation with an attorney who practices in the area. Okay, so the first question is, what is an estate plan? And an estate plan, for my definition, is a written set of directions for the disposition of your assets and your debts at the time that you either die or perhaps you become incapacitated and need something to be able to take over those assets during that period. Your estate plan will almost always include a will, may or may not include trusts, and there are both revocable and irrevocable trusts. We'll talk about the differences there. Your estate plan may also include a beneficiary designation on a bank or an investment account. It may include a survivorship property that you own jointly with someone else. This particularly in real estate. If you own real estate with another person, the deed may provide for survivorship so that it automatically passes to the other owner upon the death of the first. And then may also include, for incapacity issues, powers of attorney designation of healthcare surrogate, and those kinds of things. The plan is, you kind of have to talk about, in an estate plan, there are a number of things that you want to deal with. The estate plan is everything that you own, whether you own it individually, whether you own it solely, or whether you own it jointly with another person or persons or an entity. And you want to always, in making a plan, take into consideration that your estate may grow or that it may decline during your lifetime, potentially, as you go into retirement, depending upon what your savings and your particulars of your retirement plan are, that the estate that you're leaving to loved ones may be greater than what it is at the time you make the plan, or it may be less. And those, you talk about those particular issues, and you kind of build that into your estate plan when you first set things up. You may also take into consideration assets owned by other family members or held in trusts that may become available to you, that you then have to deal with your estate plan. Or if your plan is for a special needs member of your family, are there other people in the family who will also be contributing to that individual, in which case there may be some coordination of efforts there that need to be taken into account. All right, so what are the objectives of the estate plan? Well, the first thing we think about is that we want to be sure to get the assets to our heirs, to the people, to those that we are leaving behind. You want, if possible, to minimize costs and complications of probate. Probate is, let me just kind of define that real quickly. Probate is the formal court process by which assets are transferred to the intended heirs, and creditors and other people who may have rights to the estate are also dealt with. So you want to the extent you have debts, be sure that that is taken into account in an estate plan, that those debts are paid for to the extent they're required to be. You want to avoid unnecessary taxes. Now, this is an important kind of way of saying this. It's not to avoid all taxes. Some are going to just, unfortunately, there are some taxes that are just going to have to be paid. But keep in mind, unless you're at this point in time, unless your estate is $11 million or greater, there is no estate tax. All right. That's also sometimes called the death tax. So except for very, very large estates, estate tax is not the concern. What becomes the issue is income tax, or sometimes capital gains tax. And those taxes may need to be paid depending upon how your assets are held at the time you die and what's going to happen to them, what your heirs are going to do with those taxes. So for example, IRAs. For a lot of people, their major retirement investment is an IRA or some other tax deferred account. When you start taking money out of those accounts, it's tax-free when you put money into it, but when you start taking money out, you have to pay income tax on that withdrawal. If you leave an IRA to a beneficiary, when they take money out of that IRA, they have to pay income tax on it. Okay, so that's, those are considerations that are sometimes taken into account in terms of how things are invested. Maybe when you roll it over to a post-tax account, a Roth IRA, depending upon who's going to be better able to pay those taxes at whatever point in time the money's withdrawn. The other kind of tax that is sometimes a consideration is capital gains tax. Capital gains tax is tax that's paid when you sell an item for more than you paid for it. and that's the simplest way to say it. For example, you buy a piece of real estate. It's not homestead. It's a second home, or it's vacant land, and you buy it for $10,000. When you sell it for $50,000, there's a gain of $40,000 in capital gains tax, which is basically a type of income tax, is paid on that $40,000 gain. When someone inherits property, they can get, at least under current law can always change, and there have been some discussion of changing what's called a step up in basis. When someone inherits a piece of land that has gained value over time, they take it not at the original purchase price, but at the value that it has when they inherit it. So that $10,000 piece of vacant property that you leave someone, and then they turn around and sell it for $50,000, they don't have to pay capital gains on that, because they get what's called a step up in value. Their basis in the property is the market value that the property had when they inherited it. If they sell it right away, they get that full cash price without any capital gains. So very often in preparing an estate plan, your attorney will talk to you about the different types of assets and how they're held, and how you might leave one to one person, one to someone else, depending upon their ability to deal with it. A primary consideration here tonight is providing for the incapacity of the planner. The next one is what we're talking about: protection of minor children and special needs beneficiaries, protection against potential creditors of beneficiaries are all of what different things that you're going to talk about in your estate plan with your attorney. Okay, so orderly transfer of assets. When a person dies, their assets are going to go to their heirs, whoever those heirs might be. Typically, your heirs are decided by what you've done in your estate plan to designate those heirs. So some of your estate plan is going to be beneficiary designations on life insurance, on 401k, IRA accounts, potentially bank accounts, investment accounts can have beneficiaries designated. The POD and TOD is payable on death and transfer on death accounts. Investment accounts, securities type accounts, usually use the term TOD. A bank savings or checking account will use POD, but it's the same thing. It's a beneficiary designation that upon your death, the person you've named will get that account essentially by operation of law without probate. Okay. They would just, the beneficiary would go to the institution that holds that account, provide a death certificate, and say, I'm a beneficiary on this account, and it will be paid over to them directly without any other, without any kind of court proceeding. Now, this is not good if you have a beneficiary who is receiving government benefits that are income or asset limited benefits, because it can disqualify them from receiving those benefits if they have, because when they receive that bank account, that 401k or whatever, they now have, first of all, an asset, and then potentially income from that asset that would disqualify them from their benefits. So these beneficiary designations are not necessarily the best way to go if the beneficiary is receiving Social Security, disability benefits, or getting Medicaid or other governmental program benefits that have limits on income and assets that the covered person can have. In addition to those, survivorship property is also can provide for a transfer of an asset. If you own property jointly with someone else, if it's a bank account, there are 2 names on the bank account or 3 names on the bank account. For the most part in Florida, joint bank accounts are survivorship accounts unless it's specifically referenced as a name is added for what's the word? I'm sorry. For convenience only, but typically if there's joint names on a bank account, it is survivorship. When one person passes away, the other person owns the account in full. Again, this is not necessarily a good thing, depending upon who that joint owner is. Part of an estate plan might be to be making gifts during your lifetime. And you can make gifts of up to $15,000 or $16,000 annually to a person without having to report it as a gift. It gets over that, you might have to report it, but tax is not necessarily due unless you, again, reach that $11 million lifetime exemption. And then we have trusts and wills. Always will have a will. Even if there's a trust, the will is still there to kind of catch anything that might have been left out of the trust. And we'll get to that when we talk more about trusts and how they work. But those are your basic ways that you're going to transfer property at death to your beneficiaries or your heirs. Minimizing probate is not always a good thing. But the idea behind it is that it can be time consuming. There's certainly some cost involved with it, not necessarily a lot depending upon what the estate is and how well it's organized. And it's also, but it can be very beneficial if there are some debts for clearing those up cleanly so that your heirs do not have to worry about creditors coming to them for an inheritance that they receive that perhaps a creditor had some rights to. But probate only will transfer by will or intestacy, if there is no will, to the proper beneficiaries those assets which are not included is a beneficiary designation or survivorship property. So the important thing to think about here is that if you have a will, say you have 3 children, one is a special needs child and 2 others are doing okay, and you want all of your children to have a share of your estate, and your will says, I leave everything to my 3 children in equal shares. Now, obviously, if you have a special needs child, you want some trust language for their provision, but the will says all 3. But now you've done beneficiary designations. Maybe you've put your eldest child as the co-owner of your bank account and your investment account, so that you can avoid probate. Well, that individual is going to own that property, and your will is not going to have anything to say about it. So these non-probate transfers and probate transfers have to be coordinated with each other. And again, that's part of what, working with an attorney will help you decide which assets do I want to just transfer outright and which ones should go through probate, if any. Payment of debts and last expenses is part of your estate plan. Really, there are, legal creditor claims and legal expenses that do have to be paid to the extent there are assets available to pay them. And again, probate is the best way to kind of get that done. There are some assets that are free of creditor claims that will pass to your heirs, exempt from any creditors that might be out there. Life insurance proceeds, if they go directly to the beneficiary, are exempt from creditor claim. Life insurance, if it's paid to your estate, is responsible for paying creditors' claims. IRA and 401k accounts, again, if they pass directly to the beneficiary or potentially to the beneficiary in trust, will be free of claims of creditors. If they are payable to your estate, they will be, creditors will have rights to those funds. So it is important to be sure that you are dealing with those things appropriately. Homestead is an exempt asset if it goes to family members. Bank accounts and investment accounts that have POD and TOD accounts, we're not really clear even yet on those, whether or not beneficiaries, whether a creditor could go against. So you left a savings account, you name your child as a payable on death beneficiary. There is still some question as to whether or not a creditor who figured that out might be able to go against that beneficiary for payment of some creditor claims. My position is assume that they can and deal with it that way. All right, so let's get down to the nitty-gritty, the will versus the trust, because that's the big question people have. So first of all, a will is a document that has effect only upon your death. It is has to be a written document in Florida. It is signed by the individual and two witnesses in each other's presence. It's subject to court supervision. It does become a public record. It can include trust provisions. Very often for a young family doing a will, it will have trust provisions in case something happens to the parents while the children are still minors. You don't really need a full-blown trust. It's not going to be a funded trust, but you want to name a trustee and a guardian for the minor children, and that can be done in the will. And assets are put into that trust after that, at that time. A trust, whoops, can I go back? How do I go back? Anybody know? Oh,
You
well.
should have a little arrow, see down at the bottom when you
There you go. Thank you. Thank you. Okay, so a trust, again, is a written document, typically in the context that we're talking about. In a trust, it's an agreement between the owner of the trust, also called the grantor of the trust, and a trustee. Now, the trustee can be the grantor, at least initially, and then a successor trustee is named so that when the grantor dies, a new trustee can just step into their shoes. But it's a legal agreement between the grantor and that trustee to use funds for the benefit of one or more beneficiaries. During the lifetime of the owner of the trust, there are some trusts where the grantor itself might be the beneficiary, and then upon their death, other beneficiaries are named. We're talking about a special needs trust. That beneficiary obviously is the special needs person. It can be established through a will, but again, we're talking about a standalone trust. So it is a document that is established during the lifetime of the grantor. And a trust, in order to be worth anything more than the piece of paper that it's on, must be funded. And by funding, we mean a transfer of assets to the trustee. So it's the John Doe Trust, and you have a trustee of the John Doe Trust. So assets have to actually be transferred to John Doe, trustee of the trust. This is done, if it's real estate, it's done with a deed. A deed actually has to be prepared, signed, and recorded, transferring the real estate to John Doe, trustee of the grantor trust. If it is a financial account, let's say now an IRA can't be put in the trust during your lifetime, but it can be left to the trustee of the trust after your death, but the beneficiary designation has to provide directly for that. But if it is just a regular investment account, stocks and securities and so on and so forth, instead of that investment account being in the name of John Doe, it is retitled. You go to your investment representative, your financial advisor, and you actually change the name of the account to John Doe, trustee of the John Doe Trust. That's what we call funding, and very often this is a step that's left out if someone is not working closely with the attorney to help them get that done. And then you get a new investment, you get a new account later, you open a new account, you get a new asset. You just take it in your own name instead of in the name of the trust. It has to get into the trust through the will or through some other mechanism. So the funding can be done through, at the time of your death, through a will, through a beneficiary designation, or it can be funded during your lifetime, where you actually complete the documentation necessary to retitle it to the trustee of the trust. All right, so I've talked a little bit already about revocable trusts. And these are trusts that are done sometimes to plan for incapacity, but it could also be where you're setting up your assets to provide for your special needs child after your death. And you can fund some of it and use it as a grantor trust, and then upon your death, you set out the terms for the special needs portion of it. There's a lot of flexibility in revocable trusts, and the idea with them is that for so long as the owner or the grantor of the trust is alive, it's kind of an invisible vehicle as far as taxes and that kind of thing are concerned. But it already establishes how the funds are going to be used, sets up a trustee for after your death to follow the terms of the trust for the benefit of those who are named as beneficiaries. I've used them for business succession planning. It can be, they're not great vehicles for tax planning per se, because they're going to be subject to any taxation that might otherwise be there, but it may be helpful for some things. Certainly for incapacity of the owner themselves, if they are concerned about not being able to handle their affairs and want a durable power of attorney may work, but for some people that's not sufficient, and they want a trustee to be able to handle those things. And then again, to control distributions to beneficiaries. And that's the aspect of the special needs trust that's particularly important, is to control the distributions to the beneficiaries. Now, whether this is for preservation of government benefits or simply for spendthrift issues where you have beneficiaries who just can't handle money, and you want to be sure that that it's not spent for inappropriate purposes or spent too fast, that it will last. You have to have a trustee who can handle the assets and preserve your plan for the beneficiaries, control those distributions. For as long as the grantor is alive, the grantor can amend or revoke the trust in any way they desire. They don't need the permission of the beneficiaries to make that change. An irrevocable trust, little less flexible because of the idea that it is in fact irrevocable. Cannot be, once it is signed, maybe some limitations that can be built into the document. The irrevocable trust cannot be changed once it has been executed. Now, if you don't ever fund it, it's just a piece of paper. But once you have the irrevocable trust and you have funded it, it is kind of set in stone as to what those funds can be used for. Even a revocable trust becomes irrevocable when the grantor dies. So when we're talking about special needs trusts, it may start as a sort of grantor revocable trust, but upon the death of the grantor, it does become irrevocable. This is where you can prevent the loss of government benefits because of the controls put in the trust for how the funds are used for the benefit of the disabled beneficiary. Irrevocable trusts are used primarily in the for taxable estates to kind of deal with complex tax issues. If it's a large enough estate, irrevocable trusts can be used to try to reduce the portions of the to reduce the amount of the estate that's taxable. Control of distributions, very often the primary reason for a trust. We want to be sure that the distributions, when you pass away, are done in a way that does not harm your beneficiary. So where you have a disabled beneficiary who's receiving government benefits, or who may become qualified at some point in the future to receive governmental benefits that are restricted by income or asset, a special needs trust is the vehicle that can be used to allow that beneficiary, say you've been helping to support that beneficiary during your lifetime, you are aware of what the government restrictions are, and are, they either live with you, and so you follow the requirements of the disability program to allow that to occur without their loss of benefit. But when you pass away, that's going to go away as well, potentially. And so how do you leave them assets that will allow them to still supplement their income, supplement their living standard, and not lose their government benefits? That's what a special needs trust is set up to do. There are restrictions on how those funds in a special needs trust can be used. If the disability payment that they're getting is used for living expenses and food expenses, which is typically what it's there for, the assets in the trust cannot go for those things. It is the better word really is a supplemental needs trust, and so it pays for and supplements those things which are not paid for by the disability payments, which, as we all know, is a lot that it doesn't cover. And there are a lot of provisions within the law that allows for receiving of some aid that reduces the benefit, but if there is sufficient funds in that trust, it's arithmetic calculations made to extend the ability of those funds to cover the lifetime of the beneficiary. And they're balancing acts. Sometimes rent might have to be supplemented, might result in a little loss of benefit, but in the end, the equation makes it worth it. So again, there's a lot that goes into that, but it's all written out in the trust. The trust provides detailed explanations of what it can be used for, what it cannot be used for, and then the trustee works with either an attorney or someone else who's well-versed in all of the requirements of the disability program to make sure the beneficiary is not disqualified. The language in the special needs trust has to be specific as to some of those issues. And then from there, the administration by the trustee has to stay within the confines of the trust to maintain that eligibility. The trusts are pretty complex. The biggest consideration for families, where we're not talking about multi-million-dollar estates, but more modest estates where you can't afford a professional trustee to administer the trust, is having a family member or friend who knows enough about the needs of the beneficiary and has the ability to talk with attorneys and understand what the requirements of the trust are. These trusts can definitely protect the beneficiaries against creditors. So for example, you have a beneficiary who maybe it's just a spendthrift kind of issue, someone who is not good at handling money and might get in trouble with creditors. And you want to make sure the money lasts for a while. Your trust can provide that the beneficiary has no rights to require a distribution from the trust. And once they get the money from the trust, once they get a payment, then creditors can try to go after that payment and they can spend it how they will. But while it's in the trust, a creditor can't force a payment out of the trust for a debt of that beneficiary. That's what a spendthrift protection is. And sometimes either to protect a beneficiary against potential creditors, or sometimes divorced spouses, there'll be language in the trust to protect against a third party being able to get at the funds before they're paid out to the beneficiary. Okay, so again, the special needs trust. The purpose is to provide for the heir who is dependent upon government disability payments, where those disability benefits are limited by the income or the assets of the beneficiary. It allows the special needs heir to receive the benefit of inheritance without being disqualified for their program benefits. These trusts are quite lengthy, they're quite detailed, but they're drafted to meet the requirements that over time the government has indicated they will accept as protecting against the loss of benefits. One of the biggest considerations in creating a trust for your beneficiary is who will be the trustee. If you're the one that's been helping the beneficiary and you're familiar with government programs and the regulations and you've been able to navigate that, who can do that when you're gone? Who knows the beneficiary well enough, knows the beneficiary's needs, and can read the trust or work with an attorney to really understand what they can and cannot do with the funds that have been used to fund the trust. That's sometimes the hardest thing to find, is someone who can do that. There are not a lot of unfortunately, there are not a lot of third-party professional trustees who will work with small trusts. So it's one of those things where the discussion really has to be had with the person who is going to take over when you leave and are not able to do it anymore, and really communicating with them and beginning that education process earlier rather than later. We've talked already a little bit about funding the trust. So first of all, it can be funded through your will. And in that kind of circumstance, typically if it's a special needs trust, what I usually recommend is that you have the standalone document that references that it can be funded through assets left through your will or through the will of other persons. So say family members are interested in contributing to the trust, you get the trust created. It has a name, it has a date, the kind of thing that specifically identifies it. And then you tell your other family members, okay, if you want to leave anything for Joe, I've set up the trust. It's the Joe Special Needs Trust dated September 27, 2021. And if you want to leave him anything, you can name the trust and it'll get put into that trust and he won't lose his benefits. It can receive funds by beneficiary designation. So again, that's a matter of working with the financial advisor on the beneficiary designation form and say that it is left, for the benefit of Joe, left to the trustee of the Joe Special Needs Trust for the benefit of Joe. And that language needs to be proper to get it into that trust. The trust can be funded while you're alive. You can set up an account. If you do that, it's kind of irrevocable as soon as you fund it. You get a separate tax ID number and you can start contributing to it. And then benefits potentially can be paid through it for the beneficiary. The thing to keep in mind with something like that, though, let's say the beneficiary has got is working at least a little bit, is working somewhat, is earning some income, but underneath the limits, they cannot put their money in the trust. Or let's say they have an accident and get a settlement of some sort through an insurance company. Those funds cannot be put in the trust that you form. There may be the ability to do a self-settled trust for that beneficiary, but that's a whole different thing. That's where the funds of the beneficiary are put into a trust, and there's a lot of permutations on that, and as far as what the requirements of that kind of thing are. But it's essential that the beneficiary's funds not go into the trust you create as what's called a third-party special needs trust. The distributions from the trust. Okay, so now you've got a trust, either you've passed away or you've funded one during your lifetime. They're receiving Social Security, disability, maybe Medicaid, and you want to get some of those funds to help out your beneficiary. So the trust, again, will be written in a way that should let your trustee know what they can and cannot do with that money. But it can't, typically it cannot go for housing, cannot go for food, but it can provide television, radio, cable. It can provide travel and education. It can provide additional medical equipment and, medical services maybe that are not provided by the insurance. It can pay premiums, but if a distribution is made to cover housing, for example, it can reduce the benefit. And then there's a mathematical equations to how much it can reduce the benefit. So sometimes it just makes sense to do some shelter-related expenses, but just with the idea in mind that it's going to reduce SSI on a it's not a straight pro rata basis, so it can work out, but those equations kind of have to be done and run before that is made. But shelter-related expenses include mortgage payments, property taxes, utilities, and then of course groceries and meals. So those distributions should be avoided. And it's also very important that trust does not ever pay cash directly to the beneficiary, because that becomes income. So it is payment made to the provider. So, it can be, you buy a television, you actually go down to Best Buy, buy the television and deliver it to the house. You don't give them a cash and say, go buy a television. You don't give them a credit card and say, go buy a television. You actually pay directly for the service or the goods that are being purchased. And again, the trust lays all of this out and explains what the trustee can or cannot do with the funds that are there. And they're static. They are drafted for what the law is now. They try to provide, the better ones try to provide some flexibility for changes in law that may come. But when the trustee is working with it, they have to, be sure, they have to keep up with what the rules are. The trustee of the trust must report the fact that the trust exists to the Social Security Administration if SSI is being received. The copy can actually be provided to them so that they can look at it and say, oh yeah, this is okay, you don't lose benefits from this, and then you actually have to follow it. The trustee is going to keep track of what they spend from the trust, what goes into the trust, what goes out of the trust, and you would need to be able to report that to the Social Security Administration so they can verify that it's being used appropriately and is not disqualifying the beneficiary. SSI on this thing is concerned that the income is not used to provide food and shelter, because that's what they're paying for. And if there's money available to pay that, then they don't want to have to pay. So the trustee has to keep appropriate records and receipts for how the money is used. And this is where we're talking about the trustee after you has to be carefully considered and educated while you're still around to help explain it to them. Maybe to meet with the trustee who helps you set up the trust and to learn about how it works in advance of need. If the trustee is also a representative payee for SSI payments, there are the representative payee has specific duties as representative payee to report what's going on. All right, that was a lot that probably just raised more questions than answers. So I would be willing at this time, if you have some questions now, keep in mind that anything that's too specific, I can't address, but I can speak in generalities. Or if there are questions raised by what I covered, please try to expand if I can.
And I'm going to go ahead and stop the recording. So all of this is totally confidential. It won't be going anywhere.